Okay, so we will get started. So hello everyone and welcome to our HR and health and safety update presented by myself, Emily, and my colleague Carol. Bit of housekeeping first. Please could you all mute to avoid any background noise interrupting the presentation. We're going to keep our video off to ensure a stable internet connection, but I'll leave it up to you if you want your video on or not. We are recording the session from this point, so if any clients that were unable to make it, we can email it over to them. So that may change your mind on whether you want your video on or not. As you may be familiar with, April every year brings around employment updates, but this year is also timed with the easing of lockdown and the roadmap that will hopefully lead us back to some kind of normality. So it's a good time to look at what has changed, legislation we need to take note of, and look ahead to any significant updates to come in the future. We will be taking questions at the end, so if you think of any as you go along, please just pop them in the chat box and we'll pick them up at the end. So for those who haven't met me, I'm Emily and I run the health and safety company Health and Safety Support Services. We're a sister company of the HR experts and we offer bespoke consultancy support in all areas of health and safety. I also work as part of the HR team at the HR experts, so my part of the presentation will cover a bit of both HR and health and safety. So this section is going to cover looking at what returning to work might look like as the roadmap plans ease us out of lockdown. We'll catch up on the coronavirus job retention scheme and how that changes over the next few months. And we'll have an overview of how the vaccination and workplace testing will affect us and look at continuing to work safely as staff return to work or continue to work in the workplace. So returning to work as lockdown eases. Your COVID-19 risk assessment should be a working document, and this will probably be the most significant change and update you've got to make for a while, so it's best to plan ahead and ensure that you can safely accommodate staff coming back into work. You need to think about cleaning schedules, distancing including hot desking, the numbers of people you have in the workplace, any visitors you have to the workplace, and vaccinations and workplace testing. We're going to discuss these in detail later, but it's important to ensure that you keep up to date with changes in the workplace as they occur. Planning for further developments, such as further relaxation of the rules, or if unfortunately we have to revert back to any previous measures. You should speak to your staff. They may have concerns or suggestions that you need to consider. Please bear in mind that some staff may have been out of the workplace for over a year, and coming back may now be as worrying as leaving it in the first place to work from home. The virus is not completely gone, and staff may have concerns over coming into a new place with people they have not been in contact with for a long time, and you need to reassure them that it's safe and listen to their feedback. We anticipate that there may be an influx of working from home requests as employees have seen the benefits of having different start or finish times and less travel time, etc. We advise that you direct any employee wishing to continue working from home, even part-time, to submit this using your flexible working policy. This gives you a structure and procedure to follow to ensure that all requests are handled fairly. You do still have the right to refuse a flexible working request for home working if there's a legitimate business reason to do so, but if an employee has successfully worked from home during the last 12 months, you need to carefully work out how it is justified to refuse it. If you need any advice or template letters in relation to flexible working requests, please speak to your HR advisor. So the coronavirus job retention scheme has had many extensions over this time, and it comes to an end on the 30th of September. Detail can be seen on the slide as to the percentages and how it changes over the next few months. So May into June, it stays at 80% of the government contribution for hours not worked. In July, it drops to 70%, August drops to 60%, continuing through to the end of September. Therefore, from July onwards, you will need to top up that furlough payment to the 80% mark for any time not worked. You can, of course, if you want to, top your employees' wages above the 80% required, but that is at your own expense. Detail is also on there about your requirement to contribute for NI and pensions. Now may be the time to review anyone that is on flexible work furlough. A reminder there that the same percentages as the previous slide apply, but for any time the employees come in and do some work, that this must be at 100% of their pay. So reviewing staff that have been on furlough or flexible furlough and looking at if their return to work will be viable. You should look at doing an analysis of the cost of keeping them on the books under furlough against having to pay them as redundancy. Just a reminder there that you cannot use the job the coronavirus job retention scheme to fund notice pay or redundancy pay. If you believe their job is no longer viable, you will need to start making decisions in the coming months about redundancy and restructure. If there is a job there for them and it's viable, you will need to plan for their return to work and communicate this with them. Again, if you need support in either of those processes, please speak to your HR advisor. It is advised, as with all payroll records, that you keep an audit or a trail of all your payments for the next 6 years, just in case of any audit of the payments you've made under the furlough scheme. So something that's come in more recent times is the vaccination and testing programmes. So for vaccination, you may have staff called up for their vaccination if they're in the thresholds to do so, and you should be flexible in allowing them to attend. Also be aware that for some people, they've had some quite adverse reactions, and so they may not be well enough to work for 24 hours or so after receiving the vaccination. So it's just about planning ahead. You also need to consider whether an employee not having a vaccination affects their ability to do their role. Vaccinations are not considered compulsory for any role, but you may specify employees having their vaccination in a risk assessment as a control measure for being COVID secure. Therefore, you need your risk assessment to cover what if your employee is not vaccinated. Remember, the vaccination is voluntary, so you will not be able to insist that your staff are vaccinated. And whilst the majority believe the vaccination to be a benefit, be aware that not everyone is in agreement or may not be suitable to receive it due to a health matter, and therefore be vigilant in encouraging it as part of your COVID secure measures. Workplace testing is advised to nip in the bud any cases being brought into the workplace. Again, it's voluntary, so the same vigilance applies to not enforcing it on your staff. The general advice is for employees to test twice a week, to carry out this test at home before entering the workplace. To avoid GDPR complications on requesting test results, as it is classed as sensitive personal data, you can rely on the legislation that an employee has to legally inform you of any reason they have to self-isolate, and one of these is that they have been tested positive. So safety in the workplace. Your COVID-19 risk assessment should include the following. Social distancing considerations. So this is 2 metres or 1 metre plus. To enable staff to be 1 metre apart, you need additional measures. These can be a face covering, sitting side by side or back to back, or screens in place between where the staff sit. You need to look at your cleaning schedules. You may want to consider fogging. This is a technique that disinfects the area with an antibacterial fog. Regular cleaning of touch points in the workplace, cleaning of communal areas, and if staff are hot desking, ensuring that the area is cleaned thoroughly between each user. Consider your team size. Maybe you want to rotate staff with a hybrid of working from home and office working to keep the numbers in the workplace appropriate. Do staff need to take staggered breaks to avoid too many being in communal or breakout areas? Utilise different office space to spread staff out, and review the maximum capacities in rooms to safely distance staff with a signage to ensure this is not breached. When thinking about visitors to the workplace, will you allow them or not? Or if you are going to allow them into the workplace, you need a check-in procedure that can utilise the NHS QR code and some form of declaration that they are free from the virus and any previous contact. As we've already mentioned, testing and vaccination. If you're going to put this process in place, you need a caveat there for those that do not wish to have the vaccine or be tested. You should brief your risk assessment out to staff prior to them returning to work so they know what to expect and can be reassured that your workplace is COVID secure. For support with your risk assessment and any potential safety measures, then please get in touch. Or for any concerns with staff being unsure about returning to work, again, please get in touch with your HR advisor. I'm now going to pass over to Carol, who is going to give the next part of the presentation.
Hi everyone, so for those of you who don't know me, I'm Carol. I'm a HR advisor for the HR experts. And in terms of the HR agenda, I'll be running through some recent employment law changes, looking specifically at Brexit and immigration rules that are now in place, and IR35, as well as some new statutory rates for various types of employee pay. There are then 2 tribunal cases that I want to discuss, and then we'll take a quick look at what's to come in future for HR. So first off then, post-Brexit immigration reform. Now that the UK has formally left the EU and the transition period has ended, it's important to make sure you understand the legal arrangements for employing EU workers. EU citizens currently working in the UK must apply to the EU settlement scheme if they wish to continue working in the UK. The deadline to apply for that is the 30th of June this year, and that will come around quickly. If after this date they have not applied, then their continued employment will be unlawful. But please note, employers cannot force an employee to apply. Instead, it is reasonable for an employer to have a dialogue with their employee. So inquire what their intentions are and request that they keep you informed of the progress of their application under the settled status scheme. Employers can continue with right to work checks for EU citizens up to the 30th of June of this year. So a passport can still be accepted as the only right to work document up until this date. After this date, though, it will be necessary for the employee to show their settled status documentation or visa, so mark it in your diaries. For European nationals and families who enter the UK after the 1st of January this year, there's no longer any advantage to holding the European passport. One slight separate bit to that, though, is that Irish citizens can continue to freely enter, live and work in the UK. Both EEA and non-EEA nationals coming to the UK to work, study or live will need a visa, and employees will need to hold and pay for a licence to sponsor non-UK resident workers. You must obtain a sponsorship licence if you intend to hire any non-UK workers. There is a minimum of £536 that you need to pay to gain the licence in the first place, and then a minimum cost of £199 applies per employee visa. So that might not sound like too much money, but depending on the number of staff you end up hiring through sponsorship, those costs could quickly add up. So be prepared, think ahead. But on the flip side, this may prove cheaper than using recruitment agencies. The new immigration system that is now live is points-based, and a total of 70 points are required for new hires. The resident labour market test has been removed now. That was done in order to ease compliance burden on employers. Instead, employers now need to look at skills, language, and salary thresholds that apply. So applicants must be qualified to at least A-level standard in terms of their skills, and they must speak fluent English. Typically, the salary threshold for a visa is £25,600 per annum. If the salary is less than this, but no less than an absolute minimum of £20,480, then employees may still be able to apply, but by trading points on specific characteristics against the salary. So, for example, if you've got a job to offer in a shortage occupation. So, as you can see, the rules that govern visa sponsorship are numerous, and the cost to hold a licence can soon stack up. So this route won't be for everyone. But if you do need to hire from overseas, it is really important that you're up to speed. The implications of these changes and the response necessary from your organisation to avoid operational issues and to ensure continued compliance with UK immigration rules will vary depending on a number of factors, but most importantly, the nationality of your workers. If you do choose to utilise the new points-based system, or if you have any EU workers currently in your team, it is worth taking the time to ensure you are doing things by the book. As it says on the screen, employing an illegal worker can lead to a £20,000 fine from HMRC, criminal charges, which could cause reputational damage, and the loss of the sponsored worker. So don't be caught out. Okay, next up, IR35. So you might be thinking, what is it? Let's start with that. So reforms to the IR35 rules on off-payroll working in the private sector came into force on the 6th of April this month. Having been delayed by a year due to the pandemic, the rules are aimed at reducing tax avoidance for contractors employed via personal service companies. And these rules make sure that workers who would have been an employee if they were providing their services directly to the client pay broadly the same tax and NI contributions as employees. Currently, this change is only applicable for medium and large organisations. So if that's you, what should you do? Step 1 is to identify a list of any off-payroll workers. So that means persons not on your PAYE. So an example, in the medical profession, that would be a locum, or another example could be a substitute teacher. Step 2 is then to make what's called a status determination for each of the off-payroll workers identified. The responsibility for making that determination now lies with the client, that's you, and not the worker. To make a determination, you need to consider 4 main factors. First of all, control. Ask yourself, what degree of control do you have over the what, how, when, and where the contractor completes the work? The more control you have, the more likely it is they should be classed as an employee instead of a contractor. Second, think about substitution. If the contractor needs to do the work themselves and can't substitute somebody else, again, that's a pointer towards employment status. The third factor is financial risk. Does the contractor take financial risk when entering into the agreement with you? For example, by paying for their own insurance. If they do, this points them towards being contractor and away from employment status. Finally, think about integration. Is the contractor embedded within your organisation? So do they have a company email? Are they on your internal phone lists? Do they wear your uniform? Are they servicing other clients regularly, or do they have a set scope of duties that is completed within your organisation regularly? So as you can see, there's a lot to think about there, but there is an online questionnaire available on the government website to help with making a status determination. Regardless of what outcome you reach, be sure to record this and confirm it to the worker in writing. That's step 3. Workers have the right to appeal the determination that you make in much the same way that, for example, employees can appeal the outcome of a disciplinary or other formal process. So do make sure you confirm the determination in writing before moving on to step 4, which is making any deductions to their payments of tax and NI at source at normal employee rates. So it's all very complex. And why does it matter? Why should you put the effort into making sure you abide by these new rules? Well, it's worth being aware of 3 key areas which IR35 changes might implicate. Firstly, financial penalties. If the party paying the worker fails to deduct NI and applicable tax, they'll be liable for any associated financial penalties. In the first 12 months, companies won't be levied a penalty as a result of making genuine mistakes, but HMRC will still expect the correct tax amount to be paid, so even genuine accidents can be quite costly. Second, the new IR35 rules might affect competition. Contractors will want to work for firms that understand the rules and the firms that have taken appropriate steps to ensure compliance so that it doesn't come back and bite them. And finally, be prepared for increased fees. Contractors may increase their fees to compensate for their loss in take-home cash due to these tax and NI contributions. Be aware the cost of contingent workers could rise. So something a little bit more straightforward now is salary payments. The national living wage, which is the highest band of the national minimum wage, increased to £8.91 an hour on the 1st of this month. In addition, note that the age threshold for the national living wage is amended so that it applies to 23 and 24-year-old workers from the 1st of this month. Previously, the national living wage was available only to those aged 25 and over. The increase in the national minimum may close the wage gap between different roles within your business, so it may require a broader review of salary offerings to roles within your team to ensure you remain competitive. But in all cases, it is best practice to write to employees to inform them of any increases to their pay, even if they are statutory. This is helpful for clear communication as well as for financial audits. A letter template is available from your HR advisor or via our HR system Enhance, which we'll be telling you a little bit more about later on. And whilst we're on the topic of salary payments, it's also worth highlighting that the Conservative government has pledged that the national minimum wage will rise to £10.50 for all aged 21 and over by 2024. So expect continued increases, and be prepared for the living wage to become available to those aged 21 and over from as soon as next year. The following statutory payments have also increased. These are reviewed every year and rise each April in line with the cost of living. The new statutory sick pay rate is now £96.35 per week, and SSP continues to be available to employees from day 1 rather than day 4, where the absence is related to coronavirus. That includes self-isolation for their own symptoms or for household members having symptoms, but it now excludes shielding as that has come to an end. It ended on the 31st of March. If you're not already aware, the government has made available a coronavirus statutory sick pay rebate scheme to claim back employees' coronavirus-related SSP. Details and eligibility criteria are available to view on the government website. As you can also see on the slide, the family-friendly and redundancy rates have also increased as shown. Some recent case law to discuss then. I'm going to quickly cover 2 recent tribunal cases which have been prominent in the media and which inform what approach to working practices we should all consider. Firstly, the case of Uber versus Aslam, which I'm sure you've all seen quite a bit about over the last couple of years. The Supreme Court has now made its final ruling, which is that Uber drivers are classed as workers, not self-employed. So this means they can now claim minimum wage, annual leave, rest breaks, and they may qualify for statutory sick pay as well as other payments and other rights. You might wonder why this matters for other employers. Well, this judgment will have enormous consequences for all those involved in the gig economy, and furthermore, it may implicate other types of regular short-term contractor-style work. So it's recommended that organisations take a long, hard look at all aspects of an engagement and the way that it operates and consider what happens in practice as well as what is written in your contract for services. So it may be time to consider offering out 0 hours contracts and accepting the extra costs of employment to avoid the risks of gig economy style work. The second tribunal case I'd like to cover with you is centred on the topic of sleeping at work. This is particularly relevant to the care sector. A previous 2002 case ruled that workers must be paid at least minimum wage even whilst asleep, and this caused a lot of controversy at the time. It's a huge cost to pay out. However, a recent ruling in Royal Mencap Society versus Tomlinson Blake from this year has swept this aside. So in this 2021 case, the tribunal concluded differently. They said the Low Pay Commission had not intended anyone who was permitted to sleep could be deemed to be working, meaning the national minimum wage would not apply. But be aware that this case is not regarded as binding case law, so the rules remain open to interpretation based on individual circumstances. What is absolutely clear for now is that if a worker is actually called on to respond, that time will count and be subject to at least national minimum wage. Okay, let's take a look at what's on the horizon then. The government launched a number of consultations to review certain areas that were highlighted in the Good Work Plan back in 2017. Many proposed employment law changes that the government has put forward in these last few years have stalled, mainly as a result of the focus on Brexit and more recently the coronavirus pandemic. However, their attention is now slowly returning to these items and changes are on the horizon in these 3 areas. Firstly, the right for workers to request a predictable contract. So the government has suggested it will look to legislate for the rights to request a predictable contract and make that available to workers with 26 weeks continuous service or more. Examples of what might be requested include a guaranteed minimum number of hours and certainty as to the days on which an employee will be asked to work. This new development will predominantly benefit individuals who are employed as casuals or on 0-hour contracts. The aim being to give workers the right to reasonable and recordable work schedules, to tackle the issue of workers being allocated shifts with limited notice, making it difficult for them to plan their lives or find other work. it's been suggested that an employer will have 3 months to make their decision on any such request. The second topic which may be subject to future change is flexible working. The government has raised for discussion a wide variety of potential changes to family-friendly rights in recent years, including proposals to make flexible working the default. This would mean employees would be given more freedom to structure the times and locations of their work, continuing the trends in home working and working around childcare that we've seen throughout the pandemic. Finally, be aware of continued attention around the legal protections given during maternity. Employers on maternity leave already have the right to be offered any suitable alternative vacancies in a redundancy situation. However, the government intends to extend this protection to cover the period from the employer finding out about the pregnancy to 6 months after the employee's maternity leave ends and they return to work. With all those 3 cases at present, there is no clear timeline on the introduction of them, but it is a matter of when and not if. So finally, whilst we're focusing on HR, and as I mentioned briefly earlier, we would like to quickly talk you through our new HR system. I'm going to hand it back over to Emily to tell you a little bit more.
Thank you, Carol. So for those clients who have recently renewed with the HR experts, you will be aware of our new HR system, Enhance. It's a cost-effective and easy-to-use system. Enhance centralises your data, empowers your teams and keeps management on top of your day-to-day tasks. The system's been built for the HR experts and we've been heavily involved in its development to ensure it offers the same bespoke service that we offer as a consultancy, concentrating on its usage from an HR end-user point of view. So the features of the system include, you can store all your employee personnel files online, removing the need for any paper-based system. You can record and monitor employee relations, so that's things such as disciplinary procedures or any grievance meetings. You can manage sickness absence, it houses the Bradford factor and can calculate that for you and advise of when the level is getting to a point where you need to take action. You can manage all leave requests, including holidays, and manage it all online, including an app that makes it user-friendly out and about. You can conduct appraisals on there, sending the appraisal form through to the employee and back to the manager, keeping the process all online. All our template documents that we talk about and usually email over to you are all accessible on there for you to then download and bespoke them as you need. You can communicate with us on there. There's a messaging function and then we can keep an audit trail and all the communication is then assigned to you as a client and we can clearly then audit and look at the type of things that we're talking to you about and track who you've spoken to and when. And you can review your HR agreement on there, so you'll be able to see when it's due to expire. If you do purchase hours with us, as some clients do, you'll be able to see track of that and what the hours have been used for across your duration of your agreement. We've got various levels of package that give you different access to different parts of the system that suit your business, with bespoke level of support from your dedicated HR advisor. This ensures you get the right level of service for your business. If you'd like a free demo of the system, if you're not already on it, then please get in touch and we will happily arrange this for you. So that brings us to the end of the webinar. We'll have a look at the chat box and see if there's any questions, but I don't think anything came through. So that either means we've covered everything and you're absolutely happy, or we've inundated you with information and you want to take some time to process it before asking questions, which is absolutely fine. So I'll give you a couple of minutes if you have got any questions that you want to put in now we've finished, but if not, both mine and Carol's contact details are on the screen now. If you haven't already got them, please feel free to send us any questions if you want to ask them privately after the session. Like I said, we have recorded this and we will be sending it out to clients. I'll include you guys on it so that you get a copy of the slides if you want to refer back to it at a later date. But there is nothing coming through. Oh, yes, there is. There is. Are we allowed to ask employees whether they will be having the vaccine as part of the risk management process? Yes, you can ask. Absolutely fine to ask them if they've had it. It's just that you can't enforce them. If they say no, that they've not had the vaccine, then you just need to have something detailed in your risk assessment that you're aware that there may be people within your organisation that haven't had the vaccine, so you can't use that as a blanket approach to say, right, we're COVID secure because everybody's had the vaccine, because you can't enforce it. But I would encourage you to find out. And it's just being okay with their answer if they say no, personal preferences aside, whether you agree with it or not. But yeah, absolutely, you can ask them if they're going to be taking part in it as and when they're offered. Anything else coming through? Give you a couple of minutes, as I say, and if not, please feel free to bob us emails, absolutely fine. If anyone isn't on Enhanced and they want more details, again, let us know and we can demo that system. But if not, then thank you everybody for joining us. We will send everything out to you. We hope that we get to see you all again soon. Hopefully face-to-face and Zoom might be able to be phased out a little bit. Thank you, Hilda, thank you. Glad you've not got any questions, but like I say, if you do have, please get in touch. But yeah, we'll hopefully see you all again soon. Let's say, hopefully get in touch if you need us. Thank you, everybody.